Okay, welcome back. Very excited for our directors panel today. We started this conference in 2014. I just have one panel, which was a directors panel only, just in the morning. That was made up of all of the current and former West Coast regional directors, and quickly found that the personalities and the insights and the interchange between everybody that came out of that was just really interesting and really popular. And that one panel turned into a whole day of panels anchored by this directors panel. So very pleased to introduce our moderator, Jordan F. And Jordan is a partner and co-chair of MoFo's Global Securities Litigation, Enforcement, and White Collar Defense Group. Jordan's truly one of the leading securities litigators in the United States. He's a fixture in the Bay Area with more than 3 decades of experience representing public companies and their officers and directors in just about every type of matter you can imagine. I recall first meeting Jordan when he was getting a lot of news and praise for winning a class action in a securities class action jury trial against JDS Uniphase, seeking $20 billion in damages, and Jordan took care of that. Welcome, Jordan.
Thank you, Bruce.
Our next panelist is Gina Choi, who has been a star at this conference since we started in 2014. Originally in her capacity as director of the SEC's San Francisco regional office, where she was on the staff for over 16 years. And today she's actually partners with Jordan at Morrison Foerster in San Francisco, representing public and pre-IPO companies, financial institutions, asset management firms, boards, and much more. Gina is known inside and outside of the SEC for her leadership when she was there and for being a fantastic lawyer in private practice. And it's always a pleasure to see and welcome Gina.
Thanks so much, Bruce.
And also delighted to welcome Michele Layne, who's also been with us every year since 2014 as the regional director in the LA office. She's been at the SEC since 2005 and has led the LA office since 2012. Under Michele's leadership, the LA office has produced some of the agency's most significant cases, including enforcement actions against Countrywide CEO Angelo Mazzillo that resulted in the largest SEC penalty ever paid by a public company's senior executive, and the SEC's first Sarbanes-Oxley Act Club Act case, and a lot more. Michele is great to work with on this conference. Michele, welcome and thanks so much.
Thank you for having me, Bruce. It's always a pleasure.
I'd also like to welcome Randall Lee, who's a partner at Cooley, also with nearly 30 years of experience in the government and the private sector, former regional director of the Pacific region of the SEC, where he was the top official there for 9 Western states, including California. The first Asian American ever to head an SEC regional office, led a staff of approximately 175 attorneys, accountants, compliance examiners, and support personnel. Randall also is an AUSA in LA and deputy chief of the major fraud section. Welcome, Randall. Good to see you.
Thanks, Bruce. It's great to be here again.
Finally, the newest member of this group, Erin Schneider, who was named director of the SEC San Francisco office in 2019, succeeding none other than Gina Choi. Erin joined the SEC in 2005, steadily rose through the ranks there, serving in the Enforcement Division's Asset Management Unit. Many of her cases are also very well known in the Bay Area, around the world, including matters involving Elon Musk's tweets. I wonder if we'll get any more Elon Musk tweet cases. We'll have to see. And the fraud involving Theranos and Elizabeth Holmes. It's been really great working with Erin on this West Coast event. Erin, welcome back.
Thanks so much, Bruce.
Okay, Jordan, it's all yours. Thank you.
All right. Thanks, Bruce, and good afternoon, everyone. Once again, I come to you from my older boys' room in Marin County. We're going to start off with a key question for the entire panel. I've been warned by my HR department I am not allowed to ask this question. So you don't have to answer it. If you don't answer it, I'll draw an adverse inference. But are you fully vaccinated and ready to go back to work? We're going to start with you, Michele.
Hi. So before I say anything, including disclosing my HIPAA information, the views I expressed today are my own and don't necessarily reflect those of the other commission staff or the commissioners themselves. And with that, yes, I have been fully vaccinated and we have been working this entire time. And as for going back to the office, I am looking forward to it. And as for venturing out into the real world, I am excited, I think, to go on a flight to the East Coast for my older son's graduation.
Congratulations. That's terrific. Erin, how about you?
So it is a very personal question. Jordan didn't give us an out until right now. But yes, I am almost fully vaccinated. I'm still waiting for my second shot to kick in. My children are not vaccinated, so that's a complicating factor. And just in terms of whether I'm ready to get back to the real life, I don't know how many of you guys have been following the New York Times articles about, are you flourishing or are you languishing? There was a quiz and you could figure out whether you were flourishing or not. And I took the quiz and it said I was, quote, ready to start flourishing. So I don't know what that means.
Well, we look forward to next year, maybe then. Gina, how about you?
I am fully vaccinated because I only had one shot. I had the J&J shot. I was a little nervous about that, but I got that at Oakland Coliseum. And I felt a little strange about it and I was a little worried, but I had it on good authority that Layne also had the J&J shot and she has special access to an infectious disease specialist. So I thought if it is good enough for Layne, it is good enough for me.
So you were trading on inside information, I guess. All right. And Randall, how about you?
Yes, I am fully vaccinated thanks to Dodger Stadium, which I have to say was a pretty cool experience to be able to get vaccinated sitting in your car. As to being ready to get back out in the world, I'm still trying to figure that out. I'm still a little, hunkered down here. Still haven't quite figured out my level of comfort, but very much looking forward to being able to go back into the office.
All right. Excellent. All right, Erin, we're going to start off easy here. So who's your boss these days? I mean, it was Melissa Hodgman, then it was Alex O, now it's Melissa Hodgman. Is it going to be someone else, someone soon? What's going on there? And are you able to move forward without knowing who's in charge?
This is a great time to just reiterate that Michelle's disclaimer also applies to me. The views I express today are my own. My view is that, yes, Melissa Hodgman is my boss. And, Melissa has been there for a really long time. I think, many folks in the audience probably know her because she certainly has brought a lot of financial fraud cases against companies and individuals in our region. In terms of whether we're able to move forward, I think absolutely. I mean, things are moving just as they always have been. As I said, Melissa's been there for a long time. So I think she has, a really great grasp on how to move things through the commission. And, we do now have 5 commissioners. I think our office has already filed cases that have been approved by all 5 commissioners. And so things are moving.
And Michele, you have a perspective on that?
It would be the same as Erin's.
Okay, excellent. See agreement there. Gina, on this topic, I've read some criticism saying that Alex O, this criticism when she was named was, and I'll just quote it here, a paradigmatic Wall Street attorney who spent over 20 years reinforcing a corrupt status quo in corporate America. Actually sounds like a reasonable business plan, but putting that aside, what do you anticipate that there's going to be another big law appointment or former prosecutor, or is there pressure from the left? And why is it always someone from Manhattan?
I think those are all good questions, Jordan. And I think the quote that you read kind of reminds us and shows how dialed in and how strongly different constituencies feel about this. The enforcement director is a very important and position at the SEC and has a lot of impact. When you asked about Melissa Hodgman, before I reiterate kind of what Erin said, I think all of us on the panel and many in the audience can attest to what an excellent attorney and leader Melissa is. She's no stranger to the West Coast. She spent a lot of time in the San Francisco regional office. investigating a case, and even litigating in front of our own Judge Alsup. So I think a lot of us feel very, in the defense bar as well as I'm sure at the agency, feel very fortunate for Melissa's leadership. But your question about whether folks will come from private practice, I think that almost all of the enforcement directors in the last 20 plus years have had experience in big firm life. And that experience has proved to be really valuable, especially in the enforcement division. But I was on the SEC Historical Society's website recently, which I would commend to anyone who is interested in this stuff. There are many podcasts, which I love. And so you can hear about different people's journeys, especially the other enforcement directors. And what you really see for the last 30 plus years is that almost every enforcement director had not really come from the outside. But they were really promoted from within, maybe recently, but, you go back to Bill McLucas or Dick Walker, Steve Cutler, Linda Thompson, and many more, like George Canellis and Stephanie Avakian. Although many of those directors had significant big firm experience, they had served as the deputy or in other senior positions at the agency and then became the enforcement director. It really wasn't until Rob Kazami, who came from a big bank, no less, who was appointed enforcement director by Mary Shapiro during the height of the financial crisis and in the wake of Madoff, who really came from the outside with no connections, had never spent any time within the enforcement division. And at that time, I would argue that it seems like that's what the agency needed. Sometimes it's the appointment itself that the chair uses to send a message or to reflect where the agency is. You hire a former prosecutor to send the message that you're going to be tough or that you value trials. Or you hire someone from outside because you want a different perspective and you want to shake things up and you want to reorganize. Or you hire someone from the inside because you want someone who respects the norms and the process.
So Gina, what do you anticipate coming down the road here?
I think that the enforcement division has been on a pretty good roll. And so I think looking at are we at a point in time where you really need to shake things up? I think certain constituencies would say yes, that we don't want more of the same. And that's up to, I guess, Chairman Gensler to decide what he feels is appropriate. But as for geography, I think you're right that they've all, not necessarily from, but definitely from the East Coast, they've come from New York and DC. So the idea of having someone from the West Coast that could shake things up, that could be a breath of fresh air, especially the West Coast regional directors that I see on my screen. But I don't know that either of them would consider that a promotion or that they would trade what they do or where they sit to move to Washington, D.C.
Maybe we won't put them on the spot about that. We'll save it for another time. So I think we have had an election and a change in administration. At least that's what most of the news channels say. So has there been a change? Have you seen a change in your budget, hiring, or priorities? Michele, what have you seen?
Yeah, so as for budgets and hiring, we're still operating under our fiscal year 2020 budget. And under that, we have been able to do some hiring, but that is the budget that was passed in the prior administration. And then as for priorities, what I can say is the division continues to build on its successes and focuses on the matters that, as we all would imagine, are important to investors and the marketplace to ensure that we're protecting investors. And so we have been and, continue, as we say, to cover the waterfront and be the cop on the beat. That being said, of course, what is important to investors and the market evolves over time as different issues that impact companies and investment products emerge. And we do take proactive steps to police those issues. One of our goals, as already mentioned, is to protect investors by ensuring that they receive full and complete and fair information so they can make informed investment decisions. And to that end, our focus continues to be on disclosure and on the mom and pop investor to be able to evaluate risks and make informed decisions. And as we often say, because it's true, we do continue to cover the waterfront.
So Michele, it doesn't sound much different from what you would say any year. Is it? Have there been any differences so far?
Well, I think in broad strokes, you have seen, like, for instance, last year, there was the formation of a COVID task force to respond to a lot of the manipulative and other activity in the markets that were taking place, exploiting the pandemic. And, we've seen all the developments with the market volatility related to the, paradigm GameStop type activity. And so, of course, we respond to that. And I know we're going to chat a little bit later about ESG, and that has become a type of investment important to a lot of investors, and the marketplace responds. And then, of course, we police that and respond to that with the tools that we have. So the specific subject area or precise market activity is new and evolves and may be different, but the approach that we take and the tools we bring to bear, while some of them are improving and developing, does remain a constant. And that's, I think, important because it gives a lot of confidence and certainty to the marketplace and to investors that, we're on the beat and we do the best to, respond to the actions out there that require us to respond.
With the change in administration, Randall, what have you seen? Have you seen any difference in what the SEC is looking at or how it's handling things?
I think it's really too soon to tell. I mean, we're still very much in a transition period. The new chair has only been in place for less than a month. There's no permanent enforcement director in place, so I think it's very much a transition period. But I will say there are, and today I know the conference is going to cover and has covered a number of specific subject matters that are likely to be priorities, but I think it's all very much speculation. What I will say is there are, I think from a very big picture standpoint, there are some questions that will be interesting to see how they get answered. Number one is, will the focus on retail investors continue to be as high a priority? I mean, it's always going to be a part of what the SEC does, but it has been a major priority over the last few years, and I think that remains to be seen. Similarly, will we see a rebalancing in the types of cases that the SEC brings? I think in the last fiscal year, the commission brought, I think 32% of its enforcement actions were offering fraud cases, which was by a significant margin the largest percentage of cases in the offering fraud area that the commission has brought in the last few years. And last year, public company accounting and disclosure cases comprised only about 15% of the cases brought by the commission. So I think it'll be interesting to see if that trend continues. I mean, the numbers so far, this year, if my rough count is correct, would suggest there might be a rebalancing. I think, right now, investment advisor cases and public company accounting and disclosure cases are ahead by a significant margin of offering fraud cases. But, we're only midway through the year, and I think it remains to be seen. And then, I think the other big question, that will be interesting to see is whether there is a continuing impact on productivity from the pandemic. Last year, the enforcement division's cases brought declined about 15 to 20% from the prior year. And I think it's probably fair to say some meaningful percentage of that was attributable to the disruption and dislocation caused by the pandemic. Everyone's sort of gotten used to that over time. And so I think it'll be interesting to see whether there's a continuing impact on productivity and as measured by the number of actions filed.
I think we're going to get into COVID and productivity a little bit later. Interesting perspective, Randall, that you think the SEC's productivity was down because the number of cases declined. But we'll come back to that. Did want to talk about one new area because I think it's almost obligatory that every panel talk about SPACs. So we're gonna talk about SPACs. So we've heard about, a year ago, I don't know that anyone was talking about SPACs, and now it's SPACs and de-SPACs and promotes. And, the SEC seems to issue a statement about SPACs like every other week, it seems. They kind of leapfrog each other, the different divisions. We got this one on March 10th. It said, it's a good advice to the public. It's never a good idea to invest in a SPAC just because someone famous sponsors or invests in it or says it's a good investment. So keep that in mind. Then I'm just going to give 30-second background for the three people in the audience who don't know how the basics of SPACs. So a SPAC is a company that goes public in an IPO specifically for the purpose of acquiring a private company within 2 years. When it finds a target, it merges with that private company, effectively taking it public, and that's called a de-SPAC. And often, maybe even always, the merger filings contain projections. I saw one commentator, I thought this was very apt, say that in a traditional IPO, the IPO papers filings are based on 3 years of historical financial results. And in a de-SPAC, it's based on 3 years projected financial results. Otherwise, they're exactly the same. So everyone's going to get a shot at this one. So Randall, what are you advising clients in this space to do? Where do you see the pressure points? There are so many different parts of this, the original IPO, the de-SPAC, the operating company, and so on. What do you think are the pressure points?
Well, first off, I think the SEC guidance is, a incredibly helpful roadmap to the issues that folks ought to be concerned about. It is unusual for the commission and for that many different divisions to have promulgated this much sort of cautionary advice, guidance, what have you, on a single topic. But, I think you have multiple pronouncements from CorpFin, from the Office of the Chief Accountant, from Investor Education, and those are obviously to some degree or another coordinated. And so I think they don't just happen in a vacuum. And so I think when read together, they give a pretty good indication of where the commission is going, and specifically for purposes of this panel, where enforcement is likely to be looking at, because enforcement often takes their lead from what the sort of regulatory divisions are saying on a particular issue. Substantively, I think the issues sort of break out into three categories or three buckets. Number one are issues surrounding that the sponsors, whether it's hedge fund managers or other financial institutions, ought to be concerned about. Those are primarily disclosure kinds of issues, whether it's disclosure surrounding potential conflicts of interest, disclosure surrounding risks, disclosure surrounding projections, performance, and the like. But one big bucket of potential concerns relate to the sponsors. For the combined public company, the new public company, that's another set of issues relating to, in large part, their fitness to operate as a public company, whether it's their internal controls or otherwise. And then I think the way I think of it anyway, the third major category are sort of gatekeepers, whether it is underwriters in the sale and promotional process, or auditors. So I think if you sort of think of the issues by category of participant in the de-SPAC process, it gives you a pretty decent roadmap.
So thanks, Randall. Gina, how do you think of it, and how do you advise clients about the issues they may face?
I think similarly, I think Randall set it forth and organized it well. We haven't seen the enforcement activity from the SEC yet, but considering the way these transactions are structured, the amount of money that's been raised, the fact that they involve retail investors, and the statements that Randall kind of alluded to coming out of the SEC about SPACs, you have to expect enforcement activity, which will start as investigations. But I do think that you'll see enforcement action coming out of the SEC. Randall already mentioned the potential conflicts and the way interests, they might not always be aligned when it comes to these types of transactions from the different participants, and all of that needs to be disclosed. But I think that the most recent statements made by the acting corp fin director and the acting chief accountant last month kind of reveal the SEC's interest and attitudes towards this form of capital raising. John Coates' statement basically sets forth theories of liability for misstatements and omissions made in the context of a de-SPAC transaction. That's the head of Corp Fin kind of throwing out some theories. I think that is somewhat unusual, and the defense bar sees that as unusual. And then on April 12th, the staff issued a statement to highlight potential accounting implications for how warrants issued to SPAC sponsors should be accounted for. And so, my sense from talking to my corporate partners, as well as from press accounts, this has had a significant chilling impact on the SPAC market. And as Randall said, I can't imagine that this was unforeseen. And to the extent that there's an attitude of skepticism or heightened scrutiny regarding SPACs from the staff at the SEC, I don't think that should come as a surprise to folks. The idea that SPACs are seen as a shortcut to public markets where they don't withstand the scrutiny of institutional investors through a traditional IPO process, folks at the SEC are going to be wary, particularly those in enforcement. That said, I do see that the quality of the law firms involved, the bankers involved, the SPAC sponsors, they're definitely of a different caliber than in traditional blank check reverse merger company situations that I think everyone on this panel has seen in the past. And maybe there's a gatekeeper function that will protect investors. But I think, like most practitioners in the space, both the SEC enforcement and the securities litigation bar, as well as insurers, as well as a lot of forensic accountants, they see this as fertile ground for litigation and SEC enforcement.
So speaking of fertile ground and what may happen, Michele, it looks like you were ahead of the game. When we were all still trying to figure out what a SPAC was, you already brought a SPAC action back in 2019, back in the before times. And it was the Benjamin Gordon action, just a quote, this may even have been your quote. So, the defendants lied to shareholders to make sure the ill-fated merger was approved so they could line their pockets with tens of millions of dollars from the merger. Well, that doesn't sound good. So Michele, maybe you could, tell us, lessons learned from that, or how, you came to be in front of the wave here.
Well, what I can do is talk to you about the case, which I think is illustrative of some of the issues that both Randall and Gina have identified that emerge in this space. So first, we brought a settled case against the former CEO, Benjamin Gordon, of the SPAC entity, which was called Cambridge Associates. And we also brought a litigated action against the de-SPACed entity, a company called Ability, which is an Israeli-based intelligence communications company. And that action is still pending in district court against the CEO and chief technology officer. But as for the settled action against the CEO of the SPAC entity, we charged him with negligently failing to take reasonable steps to conduct appropriate due diligence to ensure that the SPAC shareholders voting on the merger were provided with material information concerning Ability's business prospects, including its representations about a new, quote, game-changing product that as was going to be a big source of that company's revenue, as well as disclosures they made about an alleged backlog of purchase orders, and including there was a lack of purchase orders, as well as representations they made about their pipeline of possible future orders from customers, i.e. some of the projection issues that go along with these cases. And so we alleged those statements were false and misleading, and that on the SPAC side, the CEO, Benjamin Gordon, had failed to conduct reasonable due diligence to identify some potential problems with those projections and disclosures. And so he settled to non-fraud charges, fraud with a little f, 17A 2 and 3, and also for misleading disclosures under Section 14A for the material false and misleading statements in the solicitation of the proxy.
All right, and Erin, what about your office? Have you gotten in on the craze?
So, I a lot of people have alluded to this, right? We're always paying attention to what's going on in our region. And so, have there been a lot of SPAC sponsors in our region? There absolutely have been, and it's a lot of money. So of course we're paying attention to it. For me, I think it's, there are some similarities, I think, to some of the cases that we've seen that were brought against companies in the Valley, a couple of years ago. Now we've got a whole panel devoted to it, the Silicon Valley panel. But, many of those companies, certainly not all of them, they just didn't invest what they needed to invest in their compliance systems to make sure that they were, making truthful and accurate disclosures to their investors. With the private companies, you're mainly talking about 17A and 10B, fraud-related claims. Here, I think it is very important to pay attention to some of the statements that have come out from our Office of Chief Accountant. As soon as the de-SPAC transaction happens, those companies, which similarly may not have invested all that they need to into their compliance systems, they're subject to the full panoply of the Exchange Act. So, independent auditor, audit committees, accounting disclosure and control procedures. There are a lot of rules that go along with being a public company. And so I do think it will be interesting to see the enforcement action, if it happens, that comes out of this space. But yes, we're paying attention to it and following it.
All right, let's move on to another hot topic, ESG, sometimes called climate change in ESG, although I thought climate change came under the E. But anyway, Michele, there's obviously a lot of talk about ESG regulation, but what about enforcement? I saw an announcement back in March about a climate and ESG task force. So what's going on with that? And is this an issue primarily for investment companies and funds, or for other companies as well?
Well, it's for both. So before I get to the two major areas of the asset management space and the corporate issuer space, just to highlight what was mentioned in the press announcement of the formation of the task force. It's a enforcement division-wide task force that has around 24 folks from across the division, including accountants, attorneys, data specialists, senior officers from the home office, as well as throughout the regional offices and the specialized units. And the members of the task force have specialized experience and expertise in a broad array of matters that is relevant to ESG issues. And the task force largely is a response to the increased importance that we see investors placing on ESG issues. So we don't think it should come as any surprise here that core to the SEC's, investor protection mission, as I mentioned before, is ensuring that investors have full information that is important when they're making their investment decisions. And we have seen a huge influx of investors into the climate and ESG investments. And so the focus is on the two areas, the company disclosures and the investment advisors, ESG funds and strategies. And on the corporate disclosure side, what we're focusing on is the disclosure of climate risk under existing rules and guidance, focusing on what issuers say or omit in their public statements and public filings. For example, many firms are making disclosures about the climate or ESG related risks, and that the disclosures we're, to check and evaluate and assess whether they're not false or misleading, or whether they're omitting information that would be important to investors. So it's obviously a similar analysis based on the legal framework we have, applying it to the disclosures that are made relative to these risks. And then in the asset management space, which the focus is slightly different, obviously, because in some ways there are different rules and regulations that govern those disclosures. The focus is on the disclosure obligations, as well as the advisor's fiduciary duties, and also looking at their marketing and advertising practices with respect to how they're portraying their investments and their strategy.
So Gina, what have you seen from enforcement, and what are you advising clients to do in the ESG area?
I think ESG is definitely a focus of the entire agency, of the entire Biden administration, and also the enforcement division. You've seen high-level appointments at the SEC, new faces, new ideas, academics. And I think there is certainly a history of enforcement initiatives that come out of academic research. I think, but there are really no new rules in this space yet. And so as Michele kind of set forth the two areas, the asset management industry and what they're doing, as well as the kind of in the issuer space, at the end of the day, ESG issues, they're important to investors, but we're still talking about materiality and whether a reasonable investor and what a reasonable investor would want to know. I think there will be a lot of focus in the asset management space to see whether investment advisors are investing the way they said they've been investing and the way they market themselves, and whether their investments are in line with certain benchmarks. But for issuers, I think what's really key is having robust and effective disclosure controls and procedures. The one case that I've kind of seen pointed to in this space is Fiat Chrysler, that was brought at the end of the last fiscal year. That was a case alleging disclosure violations, misleading statements in an annual report. The case didn't involve fraud and negligence. Rather, it said that Fiat Chrysler misled investors when it said it had done an internal audit that revealed there were no emissions issues with their cars, when the audit they performed really looked at a particular, whether there were defeat devices, like there were in the VW Dieselgate scandal. So that case, I have to say, it took me a while to get my head around that. The violation did not seem obvious or blatant, and that's consistent with the charge. It's not a fraud or negligence. There wasn't a fraud or negligence charge. It's a Section 13 violation, but it did result in a $9.5 million penalty. And I'm sure it was very resource intensive for the company, as any enforcement action is. So I would say that the violations in this space don't necessarily, they're not going to necessarily result, be the product of a huge fraudulent scheme. But I think the SEC is going to be looking really closely. And I think that if any, to the extent that issuers have been contacted by environmental regulators, whether that's the EPA or here in California, the California state regulator, you really want to be meticulous and thoughtful about your disclosure.
So, sounds like there's more to come for sure in this area. So we've talked about ESG and specs, relatively new issues. Want to go back to an oldie but goodie, Reg FD. I thought everyone had sort of figured this one out. And then I see March 5, a release from the SEC about AT&T. And I thought, well, Reg FD, this is going to involve social media and tweets and all that, but it's like 3 people on the phone, IR people on the phone. And then I thought, on the phone, AT&T, I kind of get it. But it just sounded like a blast from the past. And Randall, I'll ask you, I mean, is that just kind of like a one-off? Like, yeah, that'll happen every decade. You'll see something, or do you think people have gotten and companies have gotten complacent about FD?
I don't know that people have gotten complacent. I mean, I think the principles of FD are pretty well established in the public company area. That said, the fact that principle is well established doesn't mean that people aren't going to make mistakes or do dumb things. That's just human nature. So I think I wouldn't necessarily characterize this as an anomaly either. I mean, what's interesting is that you're right on the face of the SEC's allegations. It sounds like sort of a run-of-the-mill, pretty typical FD violation or FD alleged violation. But clearly here there was a much bigger story, and clearly the facts are not nearly as plain as the SEC has made them out to be, because of the fact that AT&T and the executives are litigating the matter, which, as you know, is a pretty unusual, I would say highly unusual posture for a public company to be taking. So that suggests that there is much more to it than meets the eye. And by the same token, it also suggests that the SEC must have taken a very aggressive position in settlement, because the SEC too has an interest in and typically will settle matters with public companies. And the fact that there was no settlement to be had here would suggest a pretty aggressive position on both sides, including on the side of the SEC. So I think it's going to continue to be in an area that the SEC enforces, and this matter would suggest that standalone FD enforcement actions are something the commission's going to pursue aggressively in the right circumstance.
Erin, do you agree with that?
What I can say, I mean, just anecdotally, Jordan, we haven't brought an FD case out of our office in San Francisco for quite a few years. That does not mean that we have not investigated potential violations of Reg D. And so just because you don't see them doesn't mean that they're not a part of our not a part of our docket, because I can think of, quite a few of them actually that we've investigated over the years. In terms of this particular case, as Randall mentioned, it is in litigation. And so, I think we'll all see what happens in that litigation. But I do think people, things go in cycles. And to the extent that everybody understands, that you're not supposed to do this, I do think people make wrong choices. And then you'll see those types of cases.
Okay. I want to briefly talk about crypto. I know there was a whole panel on this and lots of discussion. Obviously, the SEC has a pretty long string of victories in this area with Telegram and Kick Interactive. Now we've got a pretty well-known case involving Ripple Labs. And the Ripple case involves tokens that were issued way back in 2013 and continuously. So a question for you, Gina, is it really safe for any crypto company? I mean, Ripple's been around, 7 years. And not only was Ripple charged, but also CEO was charged and co-founder was charged. So is it safe for any of them or not? Or is it all up for grabs?
I think this is a really interesting case. It's a case that took a lot of us by surprise when it was filed. And not because the legal analysis was so distinct when it came to XRP, but really just some of the facts surrounding Ripple. And Jordan, you've alluded to or stated, what they are. The circulation of XRP had been going on for years. The case, which was a failure to register case, didn't and doesn't allege fraud, but it did include charges against individuals, including Ripple's CEO and chairman, for selling billions of XRP. The numbers are big. So, on some level, you kind of said this before, but, the SEC has been successful with these cases. After reading the court's decision in Telegram, maybe it shouldn't have come as such a surprise. A lot of the analysis and the allegations in the complaint are based on the court decision when the injunction was granted in Telegram, which really embraces the Howey test. But I think Ripple would argue you have unique facts and circumstances. I think they think Ripple is a lot like Ether, and the SEC didn't go after Ether. They argue that XRP is a currency, that the Howey test is not the appropriate test, and that XRP is not an investment contract. And I think what's really important is the posture of the case as well. This was filed as a litigated action. This wasn't an emergency action like a lot of these have been litigated. It wasn't like a preliminary injunction. And so you have discovery, and several of the discovery issues have gone the defendant's way in this case. So, the SEC, I think the magistrate judge found, that they shouldn't be able to obtain bank accounts of the individual defendants, and the SEC may need to produce internal memos. It's a big deal. So, the vigorous litigation and defense posture here will be interesting to watch.
So Erin, how about, not necessarily on any of the cases I've mentioned, but just in general, your perspective, your office's perspective on crypto?
I mean, I do think the SEC has been really thoughtful about the types of cases that it's bringing, and I think that's been borne out by the good rulings that we've been getting. Just from our office, and I'm sure Steve talked about this a little bit earlier. We've brought quite a few cases this year in the crypto space. I think 4. 3 of them filed here in the Northern District of California. We got a good ruling on a motion to dismiss, referencing the Howey test. And so I think, we're going to continue to bring those cases because we've got staff in the cyber unit. We also have an exam part of our office that has really, really deep expertise. And so I do think you'll continue to see them, and the law will continue to develop here in this district as well.
Okay. So speaking of things we may continue to see, and Erin, I'll throw this back at you. There were a lot of COVID cases brought last year, lots of them. I mean, the SEC even went after the Cheesecake Factory. I mean, really. So are we done with all this, or are we going to have like COVID cases going on for years?
I mean, I think what you saw last year was the SEC being responsive, right, to something that was happening in the market. So we saw a lot of really quick action, right? All the trading suspensions, the fraud cases for people who were claiming, blood tests, masks, vaccines. And then you saw a public company case against the Cheesecake Factory. I think those cases, just generally speaking, tend to take longer. So will we see more of them? I think it's hard to say, but I do think it's an area that we're continuing to monitor. And look, there's still a lot of things happening out in the market with certain industries still being impacted and people going back to work at different rates. And so I think we're going to continue to monitor going forward.
Okay. All right. I think we have about a minute or 2 left. So we're going to end on a different kind of note, which is I'm going to ask each of you for something that you accomplished, not work related, over this past pandemic year. And we're going to start with Randall.
Well, nothing too terribly interesting, but my backhand has gotten a little bit better. My serve still sucks, but I'm making progress, and I've done a lot of cooking.
Are you a USTA rated player?
Not even remotely.
Okay. Call me when you are. Okay. Gina, how about you?
Something I have accomplished is, Jordan, we have adopted a puppy. Well, not a puppy, a dog. It's my first dog ever. And my accomplishment is that you didn't hear him this whole panel.
Excellent. We all appreciate that. Very good. All right. Erin, how about you?
So I started to play the ukulele, and I had a very ambitious agenda. I can play 2 Vance Joy songs, and that's about it.
That's pretty good. And Michele?
Yeah, so I succumbed to the obligatory, I'm going to make my own starter and make sourdough bread. But after it looked like something out of Stranger Things in the ball jar in our refrigerator, I did a pivot, which I know is a thing now, and took up making pizza dough, which PSA is much easier. So not perfected, but like edible. So the family eats it.
You can make the food and Erin can provide the entertainment.
There
Excellent.
you go.
Excellent. And all I
I'm
accomplished
gonna
was I got
watch
my hair
Randall
cut.
in his tennis competition.
Yes. All I did is get my hair cut. All right, Bruce, I see you're back, which means we're done. Thanks
you,
to
Jordan.
the panel. Really appreciate all of your help and all of your effort.
Thank you, Jordan. Great to see and hear from everybody. I sincerely hope we can meet up in person in San Francisco or Palo Alto very soon. But as always, the directors panel, quite a highlight. And we're really grateful to all of you for joining us and for your thoughts and for your insights.